Good afternoon, everyone. I'm Jocelyn Boyd with the Public Service Commission, and I want to welcome everyone who's listening in and or participating in today's forum regarding docket numbers 2005-83A, 2022 162E, 2023 15E, 2023 16E, and 2023 17E. The purpose of today's public forum is to address procedural schedules related to integrated resource plans, avoided cost proceedings, and other proceedings such as fuel cases. This will be our second time having a forum on that in the most recent weeks. Purchase gas adjustment proceedings, and any other proceedings that were listed in the calendars that are published in those dockets. Okay, so I will proceed to call the entities' names and those representatives whom I have listed as participating today. And I should not eliminate any participants, but if I do, please let me know. With Carolina's Clean Energy Business Association, Mr. Richard Witt and Mr. John Burns, are you present?
That's correct.
Yes, ma'am.
Yes.
Great. And will both of you be providing comments during today's forum?
I'm appearing as local counsel for SECEBA, and general counsel from SECEBA, John Burns, will actually be commenting.
Thank you, Mr. Wood.
And there is some possibility, ma'am, of Hamilton Davis signing on and commenting, but I'll be handling most of the comments for us.
Okay, just let me know when that occurs.
Will do. Yes, ma'am. Thank you.
All right. Department of Consumer Affairs let us know that they are not participating today. We'll see them tomorrow morning. Southern Environmental Law Center, Ms. Kate Mixon and Ms. Emma Clancy.
Good afternoon. This is Kate Mixon, and Emma Clancy is on as well. I think I will be handling most of our comments today, but Ms. Clancy might jump in as well if needed.
Okay. I'll put a star by your name, Ms. Mixon, as starting. Great. Duke Energy, Carolinas and Progress, Mr. Sam Wellborn.
Good afternoon, Ms. Boyd. I'm here on behalf of the companies.
Great, thank you. Good to have you. And Dominion Energy South Carolina Incorporated, Chad Burgess and Matthew Gissendanner.
Good afternoon, Ms. Boyd. I'm Chad Burgess. With me is Matthew Gissendanner, and together we represent DESC in this matter, and I'll be the person who
You're going to take the lead today?
Yes, ma'am. I'll take the lead and give the company's comments.
You get a star. Office of Regulatory Staff.
Good afternoon, Ms. Boyd. Alex Knowles on behalf of ORS.
Great. Just saw you at our transportation workshop. Thank you for coming again today. And finally, the South Carolina Public Service Authority, Mr. Stephen Pelcher.
Yes, ma'am. I'm here today, and if we have any comments, I will be offering them. Thank you.
Great. So, everybody, I have a calendar that I want to display, and just so everyone knows what our calendar looks like now, after reviewing the comments that were filed. We did the best we could to amend the calendar. And I know that there will be other comments today, but I wanted you to know, based on our review of the comments that were in writing, how we made some adjustments on the schedule. This is in no way, of course, staff is not making a decision. I just want to make everyone aware of where we are. And we'll add some additional notes today during the forum. For example, based on the written comments filed, we didn't find any objections to Dominion Energy filing its 2023 IRP on January 30th. And so that's why that color is now blue instead of yellow. All right, didn't have any comments for February. In March, based on the written comments filed, I think Dominion Energy South Carolina said it was okay with filing its avoided costs application on March 6, 2023. We will hear hopefully from Duke Energy today about that. And then based on our proceeding a couple of weeks ago, it wasn't a proceeding, it was a forum, excuse me. I think Dominion is still okay with its 2023 fuel proceeding being held on March 30th, 2023. And Dominion pointed out correctly that we needed to move the date that the commission can open its electric vehicle study docket. And so as you can see here, if you can't, we've struck that language on March 30th, that's been struck. Now, for the rate case filing, Dominion Energy, I think, stated that they were still going to comply with the settlement agreement from the prior order, so we just left that there. I don't think the company disputed that, and that's why we don't know a date based on the written comments, but we just left that note on March 31st. Okay, and then staff moved. This year, as everyone knows, the commission is holding its commission business meetings on Thursdays. We don't know what will happen in 23 until the commissioners vote at the end of this year, but we just left it on Thursday, the first Thursday in April, for the commissioners to make a decision about opening the electric vehicle docket in April of 2023. I don't think there was any dispute about Santee Cooper in the written comments that were filed following its IRP, 2023 IRP with the commission on May 15th, 2023. Duke, forgive me. I think that this was the initial date, yes. Duke Energy Progress's initial, well, the date that we discussed a couple of weeks ago. Its fuel proceeding would be held on June 1st, 2023, and then I just added this additional note here on July 6th based on our discussions. I know that the company has not commented on that yet, but that is why that note is on July 6th, 2023. From the written comments filed, it appears as if Dominion Energy is fine with conducting its avoided cost proceeding, or its avoided cost proceeding being scheduled on beginning July 10th, 2023. I think Piedmont Natural Gas Company is fine with its 2023 purchase gas adjustment proceeding beginning on July 13th, 2023. Staff struck, I have to keep referring to the dates, on July 31st, Dominion Energy's avoided cost proceeding being scheduled. So we struck that. And as you can see, it's now referenced above, July 10th. Okay. Duke Energy Carolinas and Duke Energy Progress, we left that note until we hear from you to add some additional notes for your avoided cost proceeding beginning August 14th, 2023. And then, based on the written comments filed, Dominion Energy is okay with its IRP proceeding beginning, its 2023 IRP proceeding beginning August 21st. This was the initial date in August for the Duke Energy Carolinas fuel proceeding, and there should be another date a month later down here, yes, until we hear from the company. This note is based on our discussions at the last forum. Also on September 5th, 2023, we placed this note in red because we're not sure about Duke Energy's position related to filing its 2023 IRP on September 5th. This is just a note for staff holding that date for the consultant to present its findings and be subject to cross-examination, so on and so forth, in the avoided cost proceedings for 2023. No dates in October. In November, Dominion will begin its 2023 purchase gas adjustment proceeding on November 2nd, 2023. Of course, the avoided cost 2023 avoided cost decisions are due no later than November 15th, 2023. And based on the schedule filed for the filing date for Dominion's IRP in 2023, the final order would be due here based on the written comments that are filed on November 22nd. And finally, in the month of December, Santee Cooper's 2023 IRP proceeding would begin on December 4th. Okay, we'll review the calendar year 2023 first, please. And we're now the order that I asked you all to indicate your presence here, your attendance. It will be the order by which I call each entity's name and its representative. So we're going to begin with Carolina's Clean Energy Business Association, Mr. Burns, General Counsel
Yes.
Burns. Okay. Yes, sir.
Good afternoon. I appreciate the opportunity to speak on behalf of CCBA. I also understand that there are other parties here, there, and online who have more involvement in things such as the gas proceedings and the rate proceedings than CCBA does. So I would like to make sure that my comments are taken in that context, that others may have dates that they need to be available that don't really affect Mr. Witt and myself. Our primary concern, or two, with the original proposal was that the DESC IRP and the avoided cost hearing were piled right on top of each other in July and August. I tried to keep up with you as you went through, and it seems like one of those things would be addressed, but I would have some concern with having the avoided cost hearing on August 14th, followed by an IRP hearing on the 21st. Did I read that correctly?
Okay.
when you scanned by that?
Yes, sir, Mr. Burns. No problem. I'll ask our live stream producer to show our desktop on the live stream at this point, and I'll show you the calendar. Thank you.
Mm-hmm.
So for July 10th, as you can see, this is July 10th.
Right.
We struck the wording that indicated the Dominion's IRP hearing would begin on July 10th, and then we added the avoided cost proceeding on beginning July 10th. And if you'd like for me to, I'll scroll to August.
Please.
Okay.
So I know you left the Dominion, or which of those two, blue or yellow, is still to be discussed.
Okay. So, and all of the notes on the calendars, just to be clear, are available for discussion.
Sure.
Yes. Okay. So the 21st in the blue, DESC, because I know there are a lot of D's before the 21st, but on the 21st, DESC is Dominion Energy South Carolina. So that's when the company's 2023 IRP proceeding would begin.
We at CCBA would have some concerns with that proposed schedule, only because many of the interveners on those two matters are going to be the same. I realize Dominion and Duke would not be affected by that because they're not in each other's hearings, but many of the interveners will be participating in both of those hearings. And given the necessity for pre-hearing procedures and filings, it seems like those two are really going to run into each other and make it an incredibly complicated couple of weeks there for the interveners. I don't know how long the Duke avoided cost hearing might end up being. We were able to avoid an avoided cost hearing through a settlement this past year, but I would have some concerns with having them back to back.
Okay. Okay. So you're concerned about the one beginning on the 14th and the other beginning on the 21st.
Yes, but because I think the Dominion IRP proceeding is going to require if it's anything like the last IRP proceedings, there will be filing deadlines, testimony deadlines, and things that may run right into that avoided cost hearing as well. Okay. We also wanted to at least suggest, and then I'm going to defer to my colleagues from the Southern Environmental Law Center because they have some ideas. But given that Duke is going to be coming off of the carbon plan proceeding, whatever its results are in North Carolina at the end of 2022, we suggested perhaps some alteration in the schedule that would allow Duke to propose its IRP shortly after its carbon plan proceeding, its carbon plan was developed so that they could incorporate whatever they needed to incorporate into their proposed IRP. And that Dominion then would be second as opposed to first. We thought it might be slightly more convenient and slightly more and flow better. But we wanted to at least put that up for consideration by all parties.
Okay, so Mr. Burns, first I understand what you said about Duke's carbon plan proceedings ending at the end of 22. So you're recommending that in January, where
or shortly thereafter, not necessarily right in January. But let me go back to my notes here. I've got too many tabs open. We would suggest the Dominion IRP filing in end of January, and I know some others may have some other proposals for a slightly later filing from that. But it would make sense to us that the Dominion IRP could flow out of the carbon plan proceeding a little bit more easily, and therefore may be better to go first.
Okay, so now Dominion, you mentioned Dominion. I think perhaps Dominion is currently, this is January 2023.
Right.
And that's
We
Dominion.
currently have Dominion as January 31st, right?
And yes, sir. And you're proposing that we replace with Duke?
We wanted to at least put that up for consideration.
Okay.
I mean, it may be that the company has different ideas, and we tried to reach out, and I know Hamilton had some conversations with folks, but it's worth, I think, considering and discussing.
Okay, and just to continue the conversation, when would
Yes, ma'am.
Dominion when are you proposing Dominion file its IRP, since it wouldn't be
Later in the year, in the August-September timeframe, with a hearing early in 24.
Okay, I want
And
to
this
show you.
again is just for discussion.
Okay, yes, I want to show you something else. Let's go back to that, where it's already in August.
Right. We would suggest a later IRP filing and a later IRP hearing for Dominion, with a Duke IRP hearing taking place perhaps in June. But having exchanged messages with Ms. Mixon, I know that she has an alternative proposed schedule as well, which frankly we'd be fine with because it addresses the compaction that we were talking about as our primary concern.
Okay, so
sorry to be confusing.
You're not. I have your proposal is for Duke to file its IRP perhaps on January 30th instead of Dominion, and Duke's IRP hearing would be held in June of 2023. Let's see what's there, and then I'll finish my notes.
Yes, ma'am.
Okay, so just a depth field proceeding right now.
Right.
All right. So that's number one. And number two, your proposal includes Dominion filing its IRP the latter part of 2023, either in August or September. And
yes, ma'am.
then Dominion's IRP hearing would not convene until 2024.
Yes.
Okay. All right. And I just looked at June. Let me just look at August and September. Okay, I think we were already here. Yeah.
I do not envy you your job of shuffling all this stuff around. I promise you that.
Yeah.
Thank you for the help.
Okay, and then, so in September, the DEP IRP, would be, under your proposal, would occur earlier. So we're replacing, I see what you're doing.
Yeah, flipping it.
Okay, all right. Okay, Mr. Burns, what else do you want to
Thank
talk
you.
about? Nothing?
I will just say that I know that Ms. Mixon has some proposals, and we would also think that her proposals are very workable, because they also avoid the congestion in August and July that really is our primary concern.
Okay. Thank you.
Mm-hmm.
Okay. Southern Environmental Law Center, Ms. Mixon.
Hi, good afternoon again. Kate
Good
Mixon,
afternoon.
Southern Environmental Law Center. I appreciate the opportunity to provide comments on the schedule today. As you know, we represent a variety of environmental and clean energy clients in commission proceedings, and specifically, for the 2023 schedule that was sent out in advance of this forum, we anticipate being involved in at least the Duke and Dominion IRP, avoided cost and fuel proceedings, as well as the Sandy Cooper IRP. Since filing our general comments, we've been able to review the proposed calendar in more detail. And so we do have some additional recommendations that we'd like to make today. I think generally, as Mr. Burns expressed, we're also concerned about the close proximity, especially in the summer and early fall, between several of the proposed hearing dates, especially for the utility IRP and avoided cost proceedings, but also the fuel dockets, as we expect to be involved in those as well. We don't think that the current intervals and the proposed schedules are feasible, particularly because there's also the potential for testimony and proposed order deadlines to fall on the same dates as hearings are ongoing and other proceedings. And so we think several of those conflicts or bottlenecks could be avoided by spacing the proceedings out, at least to the extent that is allowed by law. And so I'll kind of go through each of these individually. First, with respect to Dominion Energy South Carolina's IRP, the proposed schedule has Dominion filing its IRP in late January 2023 with a hearing on July 10th, which, as we noted, causes some major conflicts between the utilities' avoided costs and IRP hearings. And we think that that could be resolved if Dominion's IRP filing were pushed back. The EFA just requires the utility to file its IRPs at least every 3 years. And since Dominion's 2020 IRP was filed on February 28th, 2020, we would recommend that its 2023 IRP filing be pushed back until February 28th, 2023. With the hearing also moved from Dominion's suggested August 21st date instead to mid-September of 2023.
Ms. Mixon, let me, okay, were you through with the RP proposed schedule? I want to look at those calendars while you are going
Sure.
through each. Is that okay?
Yep, that's fine. Yeah, and I was just going to note, that would also avoid, conflicts between the Dominion or potential conflicts between the Dominion IRP hearing and the Duke avoided cost hearing.
Okay.
Just currently set for August 14th.
All right. So February 28th is your proposal as to when, and that's here, Mark. This is the month of February, the 28th.
Yes, ma'am.
When Dominion would file its IRP, and then mid-September.
I think I had kind of tentatively September 18th, but I think there is a little bit more wiggle room in September in terms of when that hearing could be scheduled.
So maybe this is their IRP. Okay, so the 11th or the 18th?
Yes, ma'am.
Okay, thank you. Please proceed.
So next I'll go to avoided cost proceedings. First, I guess as a general note, the proposed schedule anticipates the third-party consultant filing its reports after both the avoided cost hearings. We think that it would make those proceedings more efficient and also ensure that parties have time to prepare proposed orders well in advance of the Commission's November 15th decision deadline. If the consultant were able to prepare and file its reports in advance of those initial hearings, so that the parties could ask questions to the consultant about the report at that time, as well as the commission, rather than having to schedule a second hearing, as was the case in 2021. I'd also note, so with respect to Dominion's avoided cost hearing, we're generally amenable to Dominion's request to push its avoided cost hearing to earlier in July. But with our suggested change to their IRP filing date, the original hearing date of July 31st may be more feasible. But alternatively, if that hearing date were moved to earlier in July, we would recommend that instead of July 10th, that the hearing be scheduled for either July 17th or July 24th, to again avoid potential conflicts with Duke Energy Progress fuel hearing and the Piedmont PGA hearing.
Okay, so that's what those are your comments for the Dominion avoided costs.
Right.
July 17th or July 24th. And you didn't have a problem with the filing date for Dominion's avoided cost application. I don't recall what that is off the top.
No, ma'am. I think that was March 6th, and we didn't have any issues with that.
That's the same with us as well. I failed to address that in my comments, but we wouldn't have any problem with that filing date either.
Okay.
Sorry to interrupt.
All right. Move to this July 17th or 24th. That's Dominion. Okay. Yes, ma'am. Yes, ma'am.
And then one final note on avoided costs. Looking at the calendar, we just generally know that there are a lot fewer proceedings that are scheduled in the spring. And to the extent feasible, and we're certainly open to feedback from the utilities, we would, if one of the utilities were able to file in February so that a hearing could be in mid-May, that would also help alleviate some of the bottleneck.
Okay, when you say if one could file, are you referring to the avoided cost proceedings?
Correct.
Okay, so you're fine with Dominion, so maybe you're talking about Duke.
Really either utility currently, they both file at the same time and their hearings are scheduled, roughly a month apart. This is just kind of a general note that, if either of the utilities were amenable to an earlier filing, that could help just kind of free up a little bit of space in the schedule.
So if either
that
Dominion
wasn't directed to either utility in particular.
So if either Dominion or Duke could file earlier than March 6th, is that a possibility?
Yes.
And your preference would be for one to file in February and one to file in March?
Yes. That would allow one of the hearings to be moved to May, which is fairly open. And again, kind of avoid some of the multiple hearings in a month situation. But that's really more of kind of a question to the utilities, again, if that's feasible or not.
Is the issue more the filing date or the hearing date for the avoided cost proceedings for your client?
The hearing dates. I think, as Mr. Burns noted, we represent clients in both the Duke and Dominion proceedings. And so are just trying to be kind of, conscious of, potential conflicts between hearings, testimony deadlines, and knowing kind of the potential length of some of these hearings. Also wanted to just ensure that there's enough time between hearing dates to make sure that there's as little of a potential for conflict as possible.
Okay, I was trying to determine your priority. It appears as if the hearings are scheduled with sufficient time in between, then your client does not really have a problem, even if they both file on the same day. If all three companies file on the same day, their avoided cost application.
Yes, ma'am. I would say that if the hearing were moved significantly earlier for be one or the other. I think particularly Dominion, because their hearing is scheduled first, that we would also ask that the application be moved earlier to just ensure that there's enough time between the two. I think that's a little bit would be less of a concern with Duke, because their hearing date is a little bit later. But otherwise, again, yeah, the primary concern is with the hearing dates.
Okay, so July 10th, I know that you asked for us to move that date to July 17th or 24th for Dominion, and I'm looking now so Duke's avoided cost proceeding would, under the draft schedule, would begin August 14th. And what
Yes.
you're telling me is even if Dominion's avoided cost hearing in 2023 begins either on July 17th or 24th, that August 14th is not sufficient time or it's inadequate time.
No, that we're not suggesting to move Duke's avoided cost hearing date. It was just moving Dominion's proposed hearing date, and that I think that would be enough time. Ideally, I mean, I think July 17th would allow a little bit more time in between than if it were scheduled on July 24th. But I think either of those could work for us.
Okay, so I do have that for the avoided cost proceeding so far. You would like consideration to be given to Dominion's avoided cost hearing beginning either July 17th or 24th. And perhaps for the filing for the three companies, one company would file, or two of the companies would file in maybe February or March, and then the other company would file in the month that the other two or maybe one company doesn't file. For example, if Dominion files its avoided cost application in February, then the two Duke companies would file their application in March. That's correct, Ms. Mixon?
I think so. Again, this was just kind of a separate recommendation, but just to the extent that one of the utilities were able to shift its schedule earlier, the other could stay, kind of the same or, aligned with our recommendations, for Dominion, but then the other would just get moved a little bit earlier.
Is this just so your client can begin reviewing the filings earlier? Is that your reason, or?
Again, I think the reason for that recommendation is and again, it's really more kind of a question than a specific recommendation, but it would just be to try to allow just to allow more room in the schedule overall, because there is relatively less going on in the spring, to the extent that it's possible to shift any of the filings a little bit earlier so that one could be kind of during that time frame. That might be simpler, but yeah, I think it's just to kind of generally space the proceedings out, overall.
Okay, I was just really trying to get a deeper understanding, only because I see your recommendation to move the Dominion hearing. It's about a couple of weeks. Let's see. Yeah, maybe a week later or 2 weeks later than July 10th, and pretty much leave Duke's avoided cost hearing dates alone.
Mm-hmm.
Pretty much the commissioners will probably issue a scheduling order, I would think, for the avoided cost proceedings. And typically the testimony for those proceedings, the applicant's testimony is typically due 6 weeks prior to the hearing. So that's my reason for asking you about the original filing date, what impact it would have on your client, because the pre-file dates, I don't think it's not going to impact the filing dates in, February or March?
If
Yeah,
I may
March.
just,
Yes.
excuse, this is Emma Clancy, also appearing on behalf of the Southern Environmental Law Center. If I may just clarify, I think what Ms. Mixon was, our primary recommendation was for the Dominion avoided cost hearing, assuming it remains in July, to be either on July 17th or July 24th. We just wanted to also float an alternative possibility of moving perhaps one of the avoided cost proceedings up earlier in the year, which would theoretically allow perhaps one of the avoided cost hearings to be in May or June, which right now are fairly open. So that was sort of a separate alternative recommendation. And I think that moving the filing date up a little bit earlier could theoretically allow for an earlier hearing, which might allow for some more time in the summer and fall, which is already looking quite crowded with hearings. So that was just sort of a secondary alternative recommendation. And
Okay, I understand it. I understand better now what the position is. I was just wanting to understand. So I understand what you're saying now. So if one company files in March, then there would not be a need to conduct, I'm sorry, not March. If one company files or the two companies file in February, then
right.
Let's see, there's a July hearing date now for the avoided cost proceeding, and then let me find the other date.
And then
in
the
August.
August.
In August. So, long story short, the company that files in February, if that were to happen, that company or company's hearing would be in May. I think that was the proposal.
Yes. May or June. We just, in looking at the calendar, it seems like there's some more available dates in May and June. So to the extent any filing could be moved up earlier to facilitate a May or June hearing, we thought that might be another potential solution.
Thank you. That's what I was, Miss Mixon. I was just trying to clarify. I was trying to dig deeper so that but I understand what Ms. Mixon and Ms. Clancy, what you're saying. The purpose for moving the filing date into February would be to conduct the hearing in May or June.
And again, that's just sort of a secondary question. We certainly understand that there are other, considerations and constraints, but just wanted to raise it in this setting.
Yeah, I think part of the issue for the commission in part would be to make sure that we have adequate funding for if one of the company's proceedings is held prior to July 2023, to make sure we pay for the consultants' expenses. That's important. So, and our budgets, everyone knows that our budget cycle begins July 1 and ends on June 30th. So, just okay, please, Miss Mixon, I'm back to you. I just was trying to dig a little deeper, and I have that now. So I have the 3 points.
Okay. And then I only have kind of two more small things. One for the Duke company's IRPs, their comments indicated that they're considering filing their IRPs earlier than the September 5th date that was proposed in the schedule. And we would just ask that, again, to the extent that Duke chooses to do so, or the commission schedules that for that time, that filing deadline and hearing date be coordinated just to avoid conflicts with other major proceedings. And lastly, we just note that the Sandy Cooper IRP hearing is currently scheduled for December 4th, and would just request, we don't have any concerns with that hearing date, but would request that the commission just ensure that any deadlines for your proposed orders or any other post-hearing filings are that they're set an adequate amount of time after the holidays. I think we're all going to need a long holiday break after 2023. And we're happy to also follow up with a filing that outlines the deadlines that we proposed, so you can have that in writing. And of course, we're also happy to discuss further with the other parties.
Okay, that will be wonderful after today's dialogue, Ms. Mixon and Ms. Clancy, if you would, because perhaps someone could say something within the next hour or so that where you want to amend your suggestions, but it would be nice if you would file your final recommendations in writing. That would be great.
Absolutely.
Okay.
Thank you so
We'll be glad to do that as well.
Okay,
from CCBA's perspective.
Thank you, Mr. Burns, really. Okay, so Ms. Mixon, I just also want to make sure where you are right now. I understand your opinion could change in the near term, but I'm quite sure that I have written correctly that if Dominion's avoided costs filing date remains the same, you would ask the commission to consider moving the hearing date to July 17th or the 24th. One other consideration would be for one of the three companies or two of the three companies to file its avoided costs application in February, the others in March, and the company that files its application in February, the preceding hearing would be held either in May or June of 23. If we remain with the current filing date for Duke, and Dominion in March of 23 for the avoided cost proceedings, then Duke's avoided cost hearing dates would remain the same.
Yes, I think that is all correct. There is one small is kind of asterisk to that, which is that a lot of the concern leading to, I think, Dominion's request to move their avoided cost hearing earlier was because of how close their IRP hearing was in the proposed schedule. And so I think it's also possible that could stay on the July 31st date. Although I think our preference would be for it to be a little bit, to be still on the 17th or 24th. Sorry, I'll just amend that last part. You can just ignore all that. July 17th or the 24th for Dominion's avoided cost hearing.
Okay, just leave it at the 17th or the 24th.
Yeah.
Okay.
I think that'll simplify things.
All right. So now you had a couple more comments regarding Duke's RP. You had a question for the forum today. Can Duke file its 2023 RP earlier than September 5th, 2023? And finally, you'd like for the commission to be aware of its proposed order deadline or proposed order due dates. You'd ask that those be scheduled post December 2023 to account for the holidays.
Yes, and I also think possibly later in January 2023 to ensure that the deadlines are not right after the holidays.
Okay. Yeah, schedule late January 2024. And I guess we too will have to make sure they're not running afoul of the 300-day deadline to make a decision for those RP cases. Okay. Ms. Mixon and Ms. Clancy, thank you so much. I was taking notes.
Thank you.
Okay, so the next, Mr. Wellborn with Duke Energy.
Thank you, Ms. Boyd. This is a bit like timeline Jenga, right? You move one, the whole thing might fall down. So
That's right.
we have pretty modest proposals, nothing too exciting.
Okay.
If it's all right with you, I'd like to push to my colleagues at Dominion and have them go first, and then we can
Okay.
follow.
And then you'll come back to you? All
Yes,
right.
ma'am. Thank you.
You're welcome. Mr. Burgess with Dominion Energy.
Thank you, Jocelyn. I was doing my best to keep up there with all
Okay.
those recommended changes that were being suggested, and I appreciate those changes. I'm going to make this easy on you, Jocelyn.
Okay.
I think at the end of the day, the question was whether or not DESC would be amenable to those changes, and the answer is no. We're not amenable to those, and I'll give you a few reasons as to why. Number one, I certainly appreciate the concern that those parties presented. As you know, and we know, they're not statutory parties of record. They choose to participate in proceedings before the commission on a voluntary basis, and they do so knowing what the schedule looks like. So it's their decision whether to participate in proceedings or not. I think you're being very kind by receiving their feedback from parties or from potential parties who, again, who choose to participate voluntarily. So they know what they're coming to when they come to this commission. At the end of the day, the commission schedule, the company schedule, and ORS schedule are what matters. These are the entities who are charged under various provisions of the law to carry out certain assignments. As the commission staff considers the calendar, I would ask that you consider those points that I just made with respect to the volunteerism that comes with the interveners. And interveners don't drive schedules. Obviously, I think the commission's schedule, ORS's schedule, and the company's schedules should be given great weight when the commission staff is considering when to schedule these matters. The other thing I would mention to you is DSC, we looked at the schedule. As you could tell by our comment letter, we put a lot of thought into our comments. We didn't tell the commission we were going to come here and say our piece. We put it in writing and told you what we thought was appropriate. And we certainly took into consideration the pressures that are put on the statutory parties with respect to timelines that must be met under the law. It appeared to us that commission staff put a lot of time and effort and thought into that. And that's why we did not suggest any major disruptions of the schedule. You have a lot of moving parts to attend to, and we certainly respect that. The only change that we suggested to the commission staff was really just a flipping of a hearing date with respect between the avoided cost proceeding and the IRP proceeding, and delaying the IRP hearing by a few weeks. And the reason we asked for the commission to do that is due to personnel and staffing reasons. The persons who prepare the avoided cost filing and who participate in the avoided cost hearing, and I'm not talking about lawyers, I'm talking about, because I'm not worried about me and Matt, our time. We'll be here when we have to be here. I'm talking about the folks who work back at the company, who crunch the numbers and calculate what needs to be done in order to come up with the IRP and also with the avoided cost calculations. They're the ones who also testify in both hearings. And that was a simple request to just give them a little bit of a breather between those two hearings. We did not envision that to be a heavy lift, because we did not think that we were putting any unnecessary pressure on the commission. We thought that by delaying the IRP hearing until August 21st, that would be not a huge problem for the commission, because it still gave them roughly 18 weeks to make a decision. And we certainly have been listening to the commission over time, and given the fact that they have big decisions to make, we've heard the commission indicate that they need time to evaluate the evidence, to listen to the testimony, and take the time to make the appropriate ruling. So with that in mind, we thought 18 weeks would be sufficient time for the commission to render a decision in an IRP proceeding. Now, they may need more than 18 weeks. We certainly appreciate that, but I haven't heard from them. Don't know that we will anytime soon, but at some point a schedule will be issued, which we will respect and we will follow. With respect to the avoided cost hearing, we also recognize that the commission is under a time constraint with which to make a decision in that matter. And also we recognize that the commission would like to hire an expert, intends to hire an expert, and would like them to get their report filed by a certain time. And it looked like to us that the commission was following a very similar, if not identical, cadence to the last avoided cost hearing, which the company did not have any issues with respect to coming back, getting more testimony after the merits, or at least the party's merits proceeding had finished. There was no issue there with us. The other thing I wanted to mention with respect to these proceedings is there were some comments made that the spring doesn't seem like it's very busy. That's not correct. The spring is incredibly busy for DESC. A comment like that ignores the fact that there's a fuel proceeding for DESC that is going on, which involves ORS's time, the commission's time, the company's time. It also ignores the fact that there's a DSM proceeding that is going on at that same time. There are other filings that the that the company must make, and there's also a filing that has been completely ignored, I think, by the other parties, and that is we have a gas business to operate as well. And the commission staff, I appreciate y'all putting on your calendar the date of March the 31st. That is the date by which the company is required to comply with the settlement agreement that it entered into with ORS a couple of years ago in the RSA proceeding, and we intend to honor that commitment that we made. Again, as we stated in our comments, we don't know when that filing is going to be made on an exact date. We haven't been given that direction from management, but that is something that's going to take place in the spring as well. So I want to just make sure that it didn't get left not commented to with respect to the amount of work and scopes of work that the company is required to complete in the spring. And I'm not even counting what I call emerging issues. Things pop up from time to time that require commission approval, whether it be a certain agreement, maybe an accounting order. But there's obviously a lot of churning that goes on inside these in the commission's halls and in the administrative office that you run, Jocelyn. So it's busy. Now, I certainly, again, I don't want it to seem like I don't respect other people's time, because I certainly do. But I also don't want it to be lost in this comment period that, again, the folks who have gone up before us, they come to this proceeding voluntarily, and they've made the decision to participate, which is fine. But I don't necessarily think that they should be driving the schedules with respect to the company's filings and when this commission should be having hearings. The last thing I want to mention is I want to go back to the IRP. I certainly don't have a very good appreciation and, quite frankly, don't understand why the company should be asked to delay its IRP filing until later in the year because Duke Energy has a proceeding going on in North Carolina. I certainly respect what Duke Energy is doing in North Carolina, and I think Mr. Welborn would agree with me that what they do in North Carolina doesn't necessarily drive what DESC does in South Carolina, and vice versa. What DESC is doing shouldn't drive what Duke decides to do or not do. So I don't think that has one thing to do with the other with respect to the IRP date. And I think Ms. Mixon hit on this, rightfully so. There is a statutory provision that DESC must adhere to with respect to the IRP, and that is it states in the statute that the IRP filing must be made at least every 3 years. Pushing that back farther into the year, August, September, I heard Ceciba mention that earlier, that's not allowed under the law, at least under Chad's interpretation of Integrated Resource Planning statute. Again, I'll conclude by saying we appreciate what you've done here, Ms. Boyd, by bringing everybody together and listening to their comments. I would ask that you apply the appropriate weight to these comments as the commission staff goes back and evaluates them. But again, as you do that, our position was to not disrupt the commission staff's calendar, or I should say to not disrupt it any more than we thought we had to do. And unfortunately, having an avoided cost hearing followed by an IRP hearing roughly 2 to 3 weeks later does put an incredible amount of burden on the DESC personnel who prepare those filings. And the last thing I would mention is all of these filings, they snap together and they're sequenced appropriately with respect to the IRP, avoided cost, fuel, the hearings. I've lost track of how many times I've heard other parties in other proceedings say you should do this first and then do that, and now I'm hearing it's okay to do that over this. So I would just ask that those matters that have been presented to you as a matter of convenience be disregarded, and I would ask that the commission staff give great weight to what the company DESC has proposed here with respect to the schedule. We had some other comments I think you wanted to hear from us with respect to the fuel proceeding and also to the PGA proceeding. We have indicated to you on a couple of occasions now that we have no objection to the schedule that the commission staff has laid out. We're perfectly fine with that. The other thing I would point out is if the commission staff does accept some of the recommendations presented by the other parties with respect to pushing things back into the year, again, what that's going to do is there are other matters that the company has to tend to later in the year, for example, the PGA proceeding. So, and that is a proceeding where some of these other parties don't intervene in or have not intervened in. So they may not appreciate what the company has to do, what ORS has to do, and what the commission and the commission staff have to do with respect to that. So really it's a function of what may appear on its face to be pushing things out that don't seem to be a big deal. It is a big deal because there are other proceedings out there that will be impacted if those recommendations are accepted. I'll conclude by saying, Jocelyn, I heard a lot of things for the very first time today. And so this is Chad responding on the fly. So to the extent that other parties may file comments with this commission, I would just simply ask that we also be given an opportunity to respond accordingly if something else comes in those comments that we haven't heard today, or if there's a different type of argument that may be made in those comments. So
Okay.
That's all I have, Jocelyn. I'm happy to answer any questions that you may have.
Okay, well, thank you for bringing that up too, because I think if we can all agree on some type of schedule today for comments afterwards, so that staff doesn't, staff ensures that everyone who wants to comments prior to staff presenting a schedule to the commissioners. So thank you for mentioning that. I don't need to forget for us all to talk about some type of short schedule for written comments after the conclusion of today's forum. And yes, ma'am. Is that Ms. Nixon?
To interrupt, but may I respond briefly to some of those comments?
Yes, ma'am. I'm going to call on you in a second. I want to make sure I don't have anything else for Mr. Burgess. I don't think I do at this point, because he's, yes, ma'am, Ms. Mixon. Please proceed.
Thank you, Ms. Boyd. With all due respect to Mr. Burgess, the right of interveners to participate in these proceedings is also protected in South Carolina law. And while we may choose to be in these proceedings, and in one way, it is for a reason. I'm sure that the utilities would prefer that there were no interveners sometimes, because we are there and often critique or challenge their proposals, but representation from parties other than the utilities is integral to these proceedings. And we certainly hope that our participation is valued and considered in making these decisions. Also, I'd add that the reasons for many of our recommendations around the hearing date, they're to help the commission and other parties as well, not just ourselves. We represent clients in multiple utilities proceedings, but the commission also has to be at all of those proceedings. The Office of Regulatory Staff is also across multiple utilities proceedings. And there are many other parties that also might be interested in ensuring that the schedule allows for full participation. And so many of our recommendations to shift the hearing dates, they're intended to avoid potential hearing conflicts that would affect everybody, not just our set of clients.
Yes, ma'am. Thank you. One
May
other
I
thing.
also add one thing, ma'am?
Sure, is that Mr.
Without,
Burns?
yes, ma'am, John
Okay.
Burns.
Yes,
I don't
sir.
want to draw it out. We'll respond in writing with our proposed schedule to some of the things stated by Mr. Burgess. But I would echo Ms. Mixon's comments and moreover say that in response to one statement that other parties did not put thought into their presentation in writing and came to address you today, that was because we had hoped and in fact had ongoing communications with the utilities about these issues and with our colleagues on the intervener side, and hope to be able to bring some more thoughts to you after those discussions took place. If Mr. Burgess isn't aware of those discussions, I really can't comment as to why, but we'll definitely respond in writing, and thank you.
Thank you. Thank you both. Ms. Mixon, I can assure you that the commissioners do review everybody's, all parties' testimonies and filings here. So, but thank you for your comments. As you were talking, Ms. Mixon, I did want to ask Mr. Burgess one thing about the gas proceeding, potentially. So if the company files its gas rate case, typically the commission holds rate case hearings the 4th month after the filing. So that could be if you file in your gas rate case in January, that could be held in May. And we will probably note that because we don't know when the company will file, May, June, or July of next year, depending on when you file.
I think that's fair, Jocelyn.
Okay,
yes.
so I want to make sure we note that in the calendar. Okay, Mr. Welbar.
Thank you, Ms. Boyd. And like others have stated, I also appreciate the careful preparation of staff of the calendar here. I mean, it's really an excellent starting point for these conversations. And it, like Chad said, it's clear that a lot of thought went into it. So kudos and thanks there. I'll quick respond to one of Ms. Mixon's suggestions or proposals, which was that one of the utilities file their avoided costs filing in February of next year. For us, it's not possible. We had planned internally to make that filing in April. The draft schedule has us making it in March, which we determined would be feasible. We have a new reporting obligation coming out of the Duke Progress fuel case related to modeling avoided T&D, and only mention that detail because it's going to require internal work that simply would make the February filing proposal impossible for us. So just wanted to address that since it was hanging out there. The other modest proposal, at least in my view, from the companies would be to move our 2023 IRP filing up 2 weeks. So our comments that we had filed had referenced the possibility of Duke filing it filing it early in any case, and that'll give us basically a little bit more flexibility internally in terms of workload and internal resources. I don't think it would be too disruptive, but we can talk through that. So that's really the only proposal that we have. Otherwise, the avoided cost timeline looks good. Everything else appears to work.
Okay, so we have on here September 5th, and you're saying the companies are considering filing the IRP.
That's right. So the date that I've penciled is August 15th for that filing.
Okay, thank you. All right, so the modeling for your T&D for your upcoming avoided cost date for your human resources, basically February will not work.
That's correct.
2023. And then for the IRP, consider moving the Duke and Duke IRP filing date to August 15th.
That's right, from September 5th to August 15th for Duke Carolinas and Duke Progress.
Okay. Okay, thank you. And is it appropriate for me to ask you about those fuel dates?
It's not a prep review. No,
Oh, really?
I'm
Okay.
actually, I'm not necessarily prepared to ask for them. I think our latest correspondence to the commission was that we were in discussions with ORS in terms
Oh,
of the
yeah.
fuel, and so I'm not sure where those conversations are, and
Okay.
am not prepared to speak to them.
Okay,
Sorry.
no problem. I'll I'm asking them, so I need you to kind of think about that when we talk about the comments post deadline, post this forum. Okay, because
Yes.
that's going to trigger when staff will be able to speak to the commissioners about all the issues in the schedule, including
Understood.
the fuel. Okay. All right. Thank you, Mr. Wellborn. 2 things. Ms. Mixon and Ms. Clancy and Mr. Burns. I'll start with Ms. Mixon. Did you hear were you able to take notes about what Mr. Wellborn said about the February filing date for the avoided costs application?
I did. And again, that was a question to the utilities, if that's not
Okay.
feasible.
Okay.
We understand
Agreed.
that. And also we don't have any objection to their proposed date for filing their IRP.
Okay, thank you. I think I heard Mr. Burns trying to say something.
Just agreed.
Okay.
What Ms. Mixon said. Yes.
Okay, thank you, Mr. Burns.
May I ask?
Yes, sir.
If when would you like us to submit post forum comments?
We're going to talk about that in just a minute. I have one
Okay.
more person, I think. No, I have
Thanks.
2 more. I have 2 more, and then we'll come back to the schedule. Yes, sir.
Thank you.
Yes, sir. Okay, Alex. I hope it's okay if I call you Alex. Are
Yes,
you
ma'am,
ready?
of course.
Okay.
Yeah. Well, yeah. Thank you, Jocelyn, and thank you to you and your staff, like everybody else has said, for pulling all this together. So, as stated in ORS's June 1st letter, ORS generally does not object to the procedural schedule and filing deadlines that the commission staff has proposed. ORS's overarching concern is to have enough time to conduct a full and thorough review in each proceeding that is the subject of this workshop. And ORS, from its perspective, believes that the Commission's proposed schedule does afford ORS sufficient time. ORS recommends moving the commencement of DES's IRP hearing date from the Commission's proposed date of July 10th, 2023 to late August of 2023, which is consistent with DES's recommendation. ORS respectfully submits that this change will help to mitigate congestion and resource commitment constraints surrounding the numerous hearings anticipated to take place in July and August 2023, and to more closely align the amount of review time between the date of the IRP filing and the IRP hearing amongst DESC, Santee Cooper, and the Duke companies. ORS doesn't object to DES's request to move its avoided cost hearing start date from July 31 to 2023 to July 10th, provided that DES's avoided cost filing date is moved up by a commensurate amount of time. This was not an item that ORS had spoken with DESC about in advance of the workshop, and I understand that DESC may have a concern with that, so that might be an item that will need further discussion. So, based on my understanding that DESC would not be in a position to move its avoided cost filing up, I think I'll have to circle back on whether ORS would be okay with the July 10th filing deadline. Excuse me, the July 10th hearing date. Let me see. And as far as Mr. Wellborn's proposal on an August 15th filing date for the Duke Company's IRP, that would be acceptable to ORS.
So you're okay with the IRP desk moving its filing date to August 15th?
The
IRP.
desk IRP hearing.
Oh,
to,
the desk. I'm sorry. I was looking at DEP. I apologize.
Yeah, the ORS is fine with the desk IRP hearing occurring in late August, and ORS is fine with what Mr. Wellborn proposed as far as the Duke IRP filing date of August 15th.
Okay, so you agree with desk new IRP hearing date in August of 23. You agree with desk of what it costs filing date. I'm sorry, it's not their filing date. Hearing date of July 10th, but that's contingent upon you returning and talking to your colleagues about the fact that the earliest desk can file its of what it costs application would be the original, the March 6th, I think, that date.
Yeah, and maybe just the simplest thing that I could say was that yes, ma'am, and that ORS will have to have subsequent conversations about the hearing date and the avoided costs proceeding, and I suppose that's something that we'd ask to have the opportunity to provide follow-up comments.
Okay, sure.
On.
Sure. Yeah, so this is really the issue of the desk of what it costs proceeding and filing date is still up for discussion between you and desk at this point, because it could change.
Yes, ORS would like the opportunity to continue discussions
Okay.
there.
All right.
And Ms. Boyd,
Mr.
I was just going to
Burns.
say, DSC, we're more than happy to have a discussion with ORS about that filing deadline. And so we can chat more about that with them offline.
Okay, great. And the last note I had, Alex, was that you're fine with the Duke IRP filing date of our August 15th. I think
Yes.
I said that, but okay. All right. Mr. Welborn, I don't think no, he did. He touched on Duke. Did you have anything that you want? I know Chad responded regarding the desk discussions. Did you have anything you wanted to say in relation, okay, to Mr. Knowles?
Nothing to add. Thank you.
Okay. Mr. Burns, Ms. Mixon, and Ms. Clancy, I want to come back to you about Mr. Knowles's comments. So we'll start with Ms. Mixon.
I don't really have anything to add other than I just note that under our proposed schedule that it retains the original filing date for Dominion's avoided cost and keeps the hearing date within around kind of a week from there. But we would also be amenable if due to the extent Dominion has those discussions with ORS. If Dominion were to, push its filing date or move its filing date to slightly earlier to accommodate that difference, I think we're fine with those.
Okay.
Options.
All right. Ms. Clancy, did you have anything you wanted to add?
Nope. Miss
Okay.
Mixon covered it.
Awesome. Mr. Burns?
I think we're fine. We'll
You're
address
fine.
anything else in written comments. Thank you.
Yes, sir. All right. So, Mr. Pilcher, thank you for your patience. How are you?
Thank you. Santa Cooper has nothing to add here.
Okay.
you.
Well, you do bring some value, Mr. Pilcher. Don't say that. We're glad you're participating.
Thank you. Thank you.
All right. Okay, so everybody, now let's talk about comments. Let's just, if we can all talk about a schedule, so we don't leave this issue hanging, and that, so that we can give the commissioners time to consider, make a decision. So today is June 15th. And I want to encourage too, if people want to continue to talk for a short period of time after today's forum, that be done. So we're in June, and the beginning of our schedule, the schedule that we staff proposed. Okay, so the first date is January 30th. All right. So I think we have a little time. So let me see what day July 15th falls on.
That's a Friday.
Okay. So what if we have any initial comments from everybody due by July 15th? Okay. And then any responsive comments to those comments. So those will be the initial comments after today's forum. Will be due July 15th. And then any responsive comments perhaps by July 29th. Does anybody object to those dates?
No objections here.
Okay. Mr. Burns?
From my personal schedule, that's a little hard, but I think we can, with Mr. Witt's involvement, we can get something filed on July 15th.
Is that due to vacations? I don't want to be too
It's,
nosy.
it's due to the carbon plan filing deadline
Oh.
being that same day, but that's a North Carolina issue.
Okay,
so.
well, we can. I don't think August 5th is too late. And then we
Certainly would. Go ahead.
Okay, because then we would actually provide commissioners with everybody's position and staff's recommendations. I said August 5th. You know, sometime before the end of August at a commission business meeting.
That would be fine. I mean, if you wanted to push initial comments back to the 22nd and just move everything back a week, that would be helpful. It's just that we have a very large volume of things to file on July 15th. That's all.
No, I'll leave. Oh, you said July 15th or July 29th?
Well, I think you said July 15th would be the initial comment deadline. Is that right?
Yes, yes.
The only thing yes, July 15th is the filing deadline for all responses to Duke Energy's carbon plan.
Oh, okay. I misunderstood. All right. I'll leave it.
I may be the only one before you today that has that as an issue.
I don't have any authority, Mr. Burns, but I think make the schedule work. So let's go with the initial comments on July 22nd. That's not a problem.
That's perfect.
All right. And then we will have, what did I allow for 3 weeks? 1, 2, 3. So then responsive comments, everybody, August 12th. And I think staff can still make this work. If not, the end of August, the 1st of September. Now, with that being said, the initial schedule, everybody has desk filing its IRP. So I want to be fair. January 30th. Desk, if we present these proposals to the commissioners either late August or early September, will that be fine?
Johnson, I think that would be fine. I can't think of any reason as to why that wouldn't be fine. And there's also one thing I want to say here. Mr. Knowles, he made a very important statement that I wanted to make sure didn't get lost. And that was, he stated that ORS had the resources to handle the schedule that the commission staff has put forward. So I just wanted to thank Mr. Knowles for saying that and just make sure that that did not get lost in the commentary here today.
Oh, thank you. Thank you for saying that. I just want to make sure that, as I said, we're not rushing people, but I also understand, let's just say, for example, the commission adopts the schedule. Well, it appears from this schedule, you all are impacted first. And I want to make sure that that's still enough time at the latest, early September, that staff presents this to the commission, that doesn't impact you in your case.
That's right. I think that will be fine, Johnson.
All right. And Mr. Pelcher, you said you didn't have, you're okay right now. So, all right. So everybody, we'll look for your initial comments regarding today's forum, any post-forum comments to be filed no later than July 22nd. And then any responsive comments that anyone has regarding the initial comments will be filed no later than August 12th. Okay. Mr. Witt and Mr. Burns, do you have any other comments today?
No, ma'am. Thank you. Thank you very much.
Thank you.
Thank you.
Thank you for participating. Ms. Mixon and Ms. Clancy, do you have any further comments for today's forum?
Nope, nothing else from us. Thank you, Ms. Boyd.
Thank you. Mr. Wilburn?
All good. Thank you.
Thank you. And Mr. Burgess, Mr. Gissendanner?
Thank you, Ms. Boyd. We have no further comments.
Thank you. Alex, you have anything else?
Thank you, Jocelyn.
You're welcome. And Mr. Pelcher.
No further comments. Thank you.
Okay, thank you all very much for participating. Yeah, thank you for participating. We really appreciate it. Have a great rest of the week.
Thank you. Bye-bye.
Bye-bye.